The Corporate Affairs Commission is set to delist 100,000 inactive companies from its register over prolonged dormancy and failures to comply with statutory requirements under the Companies and Allied Matters Act. The delisting move, announced in a public notice, targets firms that have not filed annual returns or updated their ownership record for over 10 years. The CAC has granted a 90-day grace period for affected companies to regularize their status. Failure to comply could result in dissolution. The Commission said this action supports anti-money laundering efforts and promotes transparency in company operations and beneficial ownership disclosure. Dara Lanlehin, a managing associate at Dentons ACAS-Law in Lagos, joins me now for the conversation. Good morning.
It's a pleasure to be here.
Yes, great to have you in. Let's begin with what could possibly have prompted the CAC to consider delisting 100,000 companies at this scale in this, and is this action even legal, or do we expect a flurry of lawsuits if this directive is enacted in 90 days?
So it's not actually an unusual thing. The CAC does this cleanup exercise every so often, every couple of years. I believe one was done in 2023 or 2024, whereby they had a public notice and they published a list of companies, and they actually took steps to delist these companies. Now, lawsuits, there may be some companies that, because their names appear on the public notice, they will become aware of the fact that they are caught under this notice and want to take steps. Maybe then they realize that they do not want to be delisted, and they take action by either getting a court order to stem this, but it wouldn't be as litigation. It would be more to show evidence that there is no grounds that they should be on the list and be struck off. So in terms of litigation, not likely. But yes, there are ways to apply for the order to be rescinded as it appears, or rather as it applies to certain companies. If they can show proof that the CAC was mistaken, they've been filing their annual returns, then the CAC they can be, should I say, it would not apply to them, or the CAC would go back as it pertains to particular companies. But proof has to be shown. They have to apply within 30 days.
All right, we'll be tracking, that and as this story develops. But just to convey the severity of being delisted, let us into the impact this will have on companies and businesses at large.
So the whole point of the annual returns is, or rather the CAC, the public notice was as a result of companies not filing annual returns. And the whole point of the annual returns is to show that companies are active. When you file your annual returns, you're basically sending out a signal to the CAC, and these documents, this information becomes public record. And you're sending out a notice to everyone that my company is operational, my company is existing, my company is presenting records about its financial operations and even just business operations to the public, so that anyone that wants to have an idea about what this company is doing, the financial status of this company, can have this record or can be aware of it. So that's the whole point of annual returns, just to show that a company is operating and operating in good standing. So it's really for transparency. So when you think about the whole delisting, for companies that haven't been compliant, it's really a sign of investor confidence, because having these companies, knowing that this is a clear list of companies that are no longer operational, it almost clears the marketplace. So as an investor, you come into the market and you can be clear about the companies you are dealing with. You know that these companies are in good standing with the CAC. Strictly speaking, the CAC has investigated them and the CAC is happy with their operations. So for a lot of investors and market confidence, the whole point is to actually increase it and to show that the system is efficient. But to be frank and to be clear, it might not always work that way, because I'm personally aware of companies that are fully operational, at least at the last exercise, companies that were fully operational and their names were included on the list. And the question was, why is my name on the list when I have been filing my annual returns as and when due? But if this works as it should, then it boosts market confidence. It would, and it shows transparency. And you know that the companies you are dealing with, the CAC, they're in good standing with the CAC, and the CAC has carried out all the checks, and they are operational and carrying out their business effectively and efficiently.
And I think that brings us to the reason some companies fail to comply. Are there any particular challenges here, right? So perhaps not filing annual returns and, other issues raised here? And I mean, does this point to systemic challenges that make compliance for CAC regulation perhaps difficult for small businesses and other companies?
Yes, there for small companies especially, there are challenges, but not really because of the CAC per se, even though the CAC, yes, the annual returns, it's a requirement that every company 18 months after incorporation, you must have had your first board meeting, and you must have board meetings regularly, whereby the financial statements will be presented to the board of directors and eventually filed with the CAC. You have to have a registered office. But again, you have some companies, and with the whole technology, you have companies that were formed in 1970, and the business environment in Nigeria, it ebbs and flows, it's ups and downs. Some companies have just not been able to comply, and there are fees to filing. These fees add up every year, and if you don't file, if you have, maybe some companies might have missed their filing dates, or maybe the directors have passed away, or maybe the business has gone under, or maybe just for a variety of reasons, they just haven't been keeping in touch with their annual returns filings, and the fees pile up, and before you can reactivate your status at the CAC, you have to clear the entire backlog of fees. Now, for startups, small companies, their issue might be a bit unique, because not only do you have to comply with these annual returns requirements, have board meetings every single year, have annual general meetings, have a registered office. There are other statutory compliances, your taxes, depending on the industries you are. SCUMO, for special control units against money laundering, you have to file regular reports. Data protection is now a big thing. So when you put everything together, it can be a bit daunting for small companies to keep up and comply, because every year there are various compliances and they multiply depending on the industry. So yes, I think, in my opinion, CAC requirements, they can be onerous, but maybe more onerous when you combine them with the other regulatory requirements that are applicable in Nigeria. And it is difficult sometimes for small companies to keep up. Or startups, it can be very difficult. So what is the recommendation? Definitely get a lawyer or a professional advisor who can stay on track of these requirements and just be alerting these companies to the requirements that they are required to fulfill to be in good standing. Because again, investors come to Nigeria, you want to invest in a startup, you want to know that you are not throwing your money away, and this company is compliant. This company has followed all the do's and don'ts of the industry.
Yeah, I mean, definitely we want to boost investor confidence. But this exercise, there are concerns that this could disrupt legitimate businesses. How prepared would you say the CAC is to enforce this delisting without disrupting these legitimate businesses?
Now, as a lawyer, I'm going to speak with I'm here as a lawyer, so I'll speak with that hat. The CAC is one of the, I would say, it has been very efficient in the past, but this whole issue with technology and incorporating technology the integration has not been as seamless as a lot of lawyers would like. And with the whole delisting, we are gearing up for complaints from clients that might see their names on this list and wonder, why are we on this list when we have already taken steps to comply? And as I mentioned before, we've actually had that. I'm aware of clients that have been compliant, but their names are on the list and the documentation was there. So at the integration point, the CAC definitely does have issues with that. And it is, well, there's a way around it. You can appeal the decision, but it does cause a lot of headaches for companies because, again, other people, maybe they're third-party service providers, people that do businesses with these companies might see their names and think, oh, I've been dealing with a company that is not legitimate. Meanwhile, that is not the case. So yes, we hope that will not be the case, but we are anticipating that there will be some integration problems and there may be some companies that should not be on the list. But we really do hope that that is not the case.
And I think resounding there seems like get a lawyer. Now, would you say this signals a broader reform effort by regulators to perhaps even sanitize Nigeria's corporate space? And what lessons, to close this conversation, what lessons would you say startups and new businesses can learn from this whole process?
So it is a broader effort. There are so many regulatory agencies, CAC inclusive, that are trying to take steps to harmonize Nigeria's business landscape. The CAC delisting company, so that you know that every company that is on the CAC's register is in good standing. There's also the tax reforms. There's the data protection reforms. There's so many things that the federal government through the regulatory agencies are doing to make sure that Nigeria's business landscape for investors and even Nigerians playing in the field, that they are protected and they are well informed. Now for startups, what does this mean for smaller companies and even for bigger companies? Because again, a bigger company, that if you're maybe a company listed on the stock exchange and you want to invite investors to acquire your shares, then you're thinking, again, investors need to know that they're getting good value for their money. So what does this mean for big companies, small companies? It just means you need to stay on top of the regulatory requirements and changes. Nigeria is trying to ensure that a lot of best practice is being done, like global best practices followed. Having said that, there are issues. I cannot deny that. And nothing ever works as perfectly as it should generally, and maybe in Nigeria for the most part sometimes. But it is really a work in progress, and a lot of great efforts are being done to make sure that on the global stage, Nigeria can stand proud and stand well and stand knowing that it is comparable to any other economy and business environment in the world. So companies just need to watch out and follow the developments in the space through their legal advisors, professional tax, compliance, lawyers, and just make sure that they are always on the right side of the law and regulatory requirements.
Mm-hmm. And I mean, do you also, what other things do you think can be done within the regulatory space, aside, what they're doing now, to boost investor confidence? Or would you say this suffices?
No, I think there has to be a lot more information presented to people, because sometimes this notice has actually been issued. A lot of people are aware, but you'll be surprised that a lot of companies are still not aware. And another year, they're still going to have this exercise because there are still companies that are not filing their annual returns. Possibly another issue that might be the government, the federal government and the agencies might want to look at is enforcement. And to ensure that companies are, because a number of companies do want to comply with lots of requirements, but apart from the lack of awareness, there should be, should I say, a soft landing for companies that for various reasons want to comply but were not able to comply at that particular time. So it should just be a mix of things. More awareness, more notice to companies, but at the same time enforcement needs to be followed through, so companies know that for certain things it's a strict liability. And finally, for companies that a case could be made for lack of compliance or failure to comply, then they should be given a soft landing just to encourage them, because again, the business environment can be difficult at times. So for the most part, companies should be encouraged to comply, and a number of companies do want to comply, but sometimes are not able to due to maybe lack of information, lack of awareness, and possibly even lack of resources. So, but I would say the government is trying. There are a lot of incentives out there for smaller companies, and again, maybe more awareness on those incentives, but they are there, and companies should, through their advisors, be able to take advantage of them. And the government is trying to make it available to a number of companies to take advantage of. So it's a holistic effort, I would say. Companies, business advisors, and the government to work harmoniously so that everyone is aware and people can take advantage. And in terms of ensuring compliance, it's clear as that you need to do certain things to get certain results, and failure to do them will result in a certain result.
Mm-hmm. All right, 90-day grace period for compliance, file your annual returns and update ownership records. Thank you so much for your time on the show and perspective to the conversation. Dara Lanlehin, a managing associate at Dentons ACAS-Law in Lagos, Nigeria.
Thank you so much. It was a pleasure. Thank you.
All right.